Now, I'll write the new story. New names I'll use: Miles, protagonist/narrator; Lee, daughter; Donovan, son-in-law; Sylvia, PI; Philip, attorney; Cecile, notary; Ray Osborne, retired federal agent, investor; Darnell, deputy. The morning my son-in-law stood at the end of my driveway grinning like a man who'd already won was the morning he made the worst mistake of his life. He just didn't know it yet. I did. My name is Miles Chadwick. I'm 64 years old, and I spent 31 years as a senior fraud examiner for the Federal Deposit Insurance Corporation, the FDIC. I reviewed thousands of cases involving forged signatures, fraudulent transfers, fabricated documents. I testified in federal court more times than I can count. When I retired, I thought I was done with all of that. I was wrong. The deputy who showed up at my door that Wednesday morning was young, maybe 28, with the uncomfortable posture of someone who didn't want to be where he was. He introduced himself as Deputy Darnell Pierce, Travis County Sheriff's Department, and he handed me a manila envelope with both hands, the way you hand someone something fragile. "Sir," he said, "I'm serving you with notice of an eviction proceeding. The property at 4114 Sycamore Ridge Court has been transferred by recorded deed, and the new owners are initiating occupancy." Behind him, across the street, my son-in-law Donovan stood beside his Range Rover with his arms crossed, and a smile he'd been saving up for a long time. My daughter Lee was next to him. She wasn't smiling. She was looking at the ground. Donovan cupped his hands around his mouth. "You've got 30 days, Miles. Might want to start packing." I looked at Deputy Pierce. "May I see the deed?" He handed it over. I stood on my own porch, in the house I'd bought 22 years ago, in the house where my daughter grew up, and I read the document that was supposed to take it all away from me. It took me 40 seconds to find 3 things that couldn't be right. I looked up at Deputy Pierce. "Before you go," I said, "I need you to understand something. This document is fraudulent." I kept my voice even. "I know it, and I can prove it. I'd appreciate it if you didn't leave quite yet." He blinked. "Sir, I spent 31 years examining forged documents for the federal government. Please, just give me 5 minutes." Across the street, Donovan had stopped smiling. "Let me back up. Because none of this happened overnight, and if I'm going to tell it right, I need to tell it from the beginning." Lee was 27 when she married Donovan Hale. I remember the wedding clearly. A Sunday afternoon in June, outdoor venue, the kind of day where everything looks better than it actually is. Donovan was charming in the way that certain men are charming. All forward, lean in eye contact. The kind of man who makes you feel like the most important person in the room, right up until the moment he needs something from you. I noticed things. My wife Elena had passed 4 years before the wedding, and I suppose Lee and I had grown closer in that time, close enough that I could see when she was performing happiness versus feeling it. At the reception, she laughed at everything Donovan said, even the things that weren't funny. I kept my observations to myself. She was my daughter, not my client. For 2 years after the wedding, they were mostly absent. A birthday call here, Thanksgiving every other year. Donovan had something he described as a financial technology company, a platform that helps small businesses manage cash flow, he explained, though he was always vague on the specifics. He drove expensive cars and wore the kind of clothes that are designed to look effortless while costing a fortune. He talked about expansion and investors and series funding rounds with the fluency of someone who'd memorized the vocabulary without understanding the grammar. I didn't push. I'd seen enough of the world to know that sometimes the kindest thing you can do for someone you love is stay out of their business. Then, last December, Lee started calling more. Not texting. Calling, which she hadn't done regularly in years. She'd ask how I was eating, whether I'd had my annual physical, whether the house felt too big for just one person. All the soft questions that aren't really about what they appear to be about. In January, she started visiting. The first visit, she brought groceries and stayed 3 hours. We sat at the kitchen table and talked about nothing in particular. Her childhood, the neighborhood, a television show she'd been watching. It was nice. I wanted it to be nice. She was my only child. The second visit, she brought paperwork. "Dad, I've been thinking about your estate planning," she said, setting a folder on the kitchen table beside our coffee cups. "You've got everything organized, obviously, but some of these forms are outdated. I just want to make sure you're protected." I looked at the forms. They were printed on letterhead I didn't fully recognize, though the formatting looked professional. Beneficiary updates. A property maintenance authorization. A document described as an estate coordination form. I was a fraud examiner for 3 decades. I should have read every word, but she was my daughter. She was sitting across from me at the table where she'd eaten breakfast every morning from ages 4 to 18, and I genuinely wanted, to believe that she was back in my life, because she wanted to be there, not because she wanted this something from me. So I glanced at the headers. I signed where she indicated. That was my mistake, not trusting her. Trusting myself to want things so badly that I stopped paying attention. The third visit, Donovan came along. He wandered through my house the way people wander through houses they're already mentally rearranging. He paused in the hallway to look at the framed FDIC commendation on the wall. Then, at the photograph of Elena and me at the Grand Canyon. Then, at the view from the back window over the garden. "Nice lot," he said. "This neighborhood's come up a lot in the past few years. What do you think this place is worth now? $850? $900? "I don't think about it much," I said. He smiled. "You should. Smart money stays aware of its assets." I noticed Lee watching him as he moved through the rooms, not with affection, but with something tighter. Something watchful. I filed that away. After Deputy Pierce agreed to wait on my porch, I went inside to my office. I've kept meticulous records my entire professional life. It's not a habit so much as a reflex, the result of spending 30 years watching cases collapse because someone failed to document something correctly. Every deed, every financial statement, every signed document related to this property lived in a fireproof file cabinet in my home office. I also kept a log, a simple notebook where I noted every document I signed, the date, the context, and a brief description. Elena used to tease me about it. "Miles," she'd say, "you're retired. You don't need an evidence trail for your own life." She wasn't wrong, but old habits don't disappear because you stop collecting a paycheck. I pulled the original deed to 4014 Sycamore Ridge Court, the updated notary seal impression I filed when I renewed my property documents 18 months ago, and 3 recent signatures from bank correspondence. Then I went back to the porch. Deputy Pierce was still there, his patrol car idling at the curb. Across the street, Donovan had moved closer. He was pretending to check his phone, but he was watching. "Compare these," I said to Pierce, handing him both documents. "Take your time. Specifically, look at the seal positioning and the signature." He studied them for a long moment. I watched his face. He was a careful young man, the kind who takes the job seriously. "The seal on the eviction notice," I said, "is positioned at an 11-degree angle from the signature line. I've maintained the same filing practice for 22 years. Seals go perpendicular, every time, without exception." I tapped the original. "The signature on the deed you're carrying also has the wrong pen pressure on the initial M. I've had a mild tremor in my right hand since 2019, a known quantity. My M starts with a heavier stroke than that forgery suggests." Pierce looked up. "Sir, I need to advise you to contact an attorney." "I intend to. This situation, if what you're telling me is accurate, this is beyond the scope of a routine eviction proceeding." "I know." Donovan had crossed the street by then, his smile fully gone. "What's the problem? You've got valid papers. Do your job." Pierce turned to face him with the quiet authority of someone who doesn't need to raise his voice. "Sir, I need you to step back. There are discrepancies in these documents that require review. This matter is being escalated." "Escalated to what? Is it stalling?" "Sir, step back." Donovan stepped back. Lee hadn't moved from the car. When I looked at her across the street, she looked away. That afternoon, I called Philip Howarth. Philip had been my personal attorney for 11 years. A methodical man in his late 50s who specialized in property law and financial fraud cases. When I explained what had happened, there was a silence on the line that I recognized as a lawyer, thinking faster than he was speaking. "Send me the document," he said. I scanned it and sent it while we were still on the phone. 4 minutes later, "Miles, this is bad. The seal issue alone is enough to challenge the transfer, but if the signature is also forged, you're looking at a criminal case, not just a civil one." "I know what I'm looking at." "Right. Sorry. Who notarized the document?" I read the name from the deed. Cecile Wainwright. "Do you know her?" "Never heard of her." "Then that's where we start tomorrow morning." Cecile Wainwright operated a mobile notary service out of an office near the medical district, a small, neat space with plants on the windowsill and a printer that hummed constantly in the background. She was 60-something. Efficient. The kind of person who keeps perfect records because she understands their value. When Philip showed her the quitclaim deed, she put on reading glasses and looked at it for a long time without speaking. "That's my seal," she finally said. "But I didn't notarize this document." "Are you certain?" Philip asked. She turned to her logbook, an actual physical logbook, spiral-bound with every notarization recorded by hand. 2 months ago, I notarized a power of attorney for a woman named Lee Hale. It was a healthcare proxy. She said her father was elderly, and she wanted to be prepared for a medical emergency. She looked up. I never notarized a property transfer. Not for her, not for anyone named Chadwick. "Someone used your seal on a different document," Philip said. Cecile's expression hardened. "That's seal fraud. That's a separate crime on top of the forgery." We left with a sworn statement and copies of her records. In Philip's car, I stared out the window and allowed myself to feel, for the first time, the full weight of what my daughter had been part of. Not just the forgery, the planning. The layers of it, the healthcare proxy as a test run, the seal lifted from a legitimate document and transferred to a fraudulent one. Someone had thought this through carefully. "They had help," I said. Philip nodded. "This isn't two people improvising. Someone walked them through this." The someone turned out to be a man named Clayton Birch. I found a private investigator through a referral from a colleague at the FDIC's regional office, a woman named Sylvia Prentice who had moved into private practice after 20 years with the agency. She was direct, quick, and utterly without sentiment. Exactly what I needed. "Give me a week," she said when I laid out the situation in her office. "I'll tell you who Donovan Hale really is." She called on day 5. "Clayton Birch," she said. 47 years old, runs a consulting firm called Apex Legacy Advisors. His stated specialty is intergenerational wealth transfer, which in plain terms means he teaches adult children how to take assets from aging parents. He operates just barely inside the legal line, coaches clients on how to exploit estate planning processes, which documents to target, how to manipulate the paper trail. She paused. Donovan paid him $18,000 over the past 8 months. And Lee? She attended at least 4 of the consultations. I set the phone down on my desk and sat with that for a moment. Not because it surprised me, because it confirmed what I'd been trying not to know. Sylvia also found Donovan's financial situation, which was significantly worse than the Range Rover and the expensive clothes suggested. He had outstanding personal loans totaling $400,000, 2 credit lines in collection, and a business that had been generating essentially no revenue for 14 months. 3 months before the eviction attempt, he'd quietly begun marketing my property to real estate investors, listing it at $870,000, well below market value. The kind of price that generates fast offers from people who don't ask questions. He needed money immediately. My house was the closest large asset he had access to, or thought he had access to. Sylvia had also found something else. One of Donovan's larger creditors was a retired couple in Bexar County named the Fowlers, who had lent him $110,000, based on a business investment pitch. The Fowlers were in their 70s. They weren't the only ones. "How many people?" I asked. "I've confirmed 6 private lenders. Total exposure, approximately $340,000. Most of them are retirement age. 6 families who had trusted him. 6 sets of savings he'd spent on a lifestyle that was falling apart at the seams. I thought about my 31 years at the FDIC, about the cases I'd seen where the crime wasn't just about money. It was about the contempt behind the money. The calculation that certain people were too old, too trusting, too isolated to notice or fight back. I need everything documented, I said. Every lender, every dollar, every communication you can legally access. That's already underway, Sylvia said. The civil filing happened on a Thursday morning, 16 days after Deputy Pierce stood on my porch. Philip filed simultaneously a lawsuit to invalidate the quitclaim deed, an emergency restraining order preventing any sale or transfer of the property, and a formal complaint with the Texas Department of Savings and Mortgage Lending regarding the fraudulent property transfer. The restraining order was granted the same day. I learned about Donovan's reaction secondhand from a neighbor who lived 2 houses down. Donovan had called her. Apparently, he'd been charming to the whole street for months, laying groundwork, and asked whether she knew anything about my legal situation. She told him politely that she didn't, then called me. He sounded like a man realizing a door had just locked, she said. That was exactly right. Lee called me that evening, I answered. Dad. Her voice was thin, scraped clean of its usual composure. We need to talk. We do, I said. But not yet. Dad, Lee. I kept my voice level. I'm going to give you a piece of advice that you're free to take or ignore. Stop talking to me about this case. Talk to a lawyer instead, a good one, not the one Donovan picks. Silence. That's all I have to say right now. I hung up and sat in the kitchen for a long time, looking at the photographs on the refrigerator. The ones that had been there so long I'd stopped really seeing them. Lee at 8, grinning with a gap where her front teeth used to be. Lee and Elena at her high school graduation, both of them squinting into the sun and laughing. I thought about the January afternoon when she'd brought groceries and we'd sat at the table talking about nothing, and I'd let myself believe, fully, that she was simply my daughter who wanted to spend time with her father. Maybe some small part of that was true. Maybe not. I no longer trusted my ability to know the difference. The preliminary hearing was set for 3 weeks later. Donovan had retained an attorney named Boyd Wakefield, whose reputation in Travis County was built on aggressive posturing and procedural delay. He was good at what he did. He was also, I suspected, about to encounter evidence that would make his job very difficult. Sylvia delivered her full report 48 hours before the hearing. It was comprehensive enough to make me feel, briefly, like I was back at the FDIC reviewing a major case file. Bank statements, wire transfers, correspondence between Donovan and his private lenders, and, most damaging, a series of text messages obtained through one of the creditor's attorneys, messages between Donovan and Clayton Birch. One exchange from 8 months prior. Donovan, the POA went fine. He signed without reading it. He trusts her completely. Birch, good. That's the key. Once trust is established, the rest is mechanics. Donovan, how long until we can move on the deed? Birch, minimum 3 months. You need a pattern of documented access. Make sure she's over there regularly. Any unusual contact raises flags. Donovan, understood. She knows what to do. I read that exchange 4 times. She knows what to do. My daughter had been, at some point in the months prior, consciously executing a plan. Not confused. Not manipulated into something she didn't understand. Executing. I set the report down, went to the backyard, and sat in the garden chair where I used to sit with Elena on summer evenings. The roses she planted were still growing along the back fence, coming back every year without anyone tending them, which had always struck me as a quiet miracle. I sat there until it got dark. Then I went inside, made coffee, and reviewed the court filings one more time. Because whatever I felt about my daughter, whatever grief was sitting somewhere behind my sternum, it didn't change what had happened. It didn't change the 6 families who were owed money they'd never see again if Donovan's scheme wasn't fully exposed. It didn't change the fact that justice isn't a thing you choose to pursue selectively based on how much it costs you personally. I had spent 31 years believing that. It wasn't going to stop being true now. Boyd Wakefield filed a countersuit the week before the main hearing. Philip called to tell me, and I could hear in his voice the combination of exasperation and professional respect that attorneys reserve for tactics that are both shameless and genuinely clever. They're claiming undue influence, he said. Specifically, they're arguing that Lee was operating under psychological pressure from you, that years of emotional manipulation caused her to sign documents against her own interests. She didn't sign anything. She forged documents. They're claiming she signed a legitimate deed transfer voluntarily, and that you subsequently manipulated her into retracting it, that the lawsuit is retaliation. How does that explain the fraudulent seal? They're disputing the forensic analysis, claiming the examiner's methodology is flawed. I wrote methodology guidelines for document examination that the FDIC still uses. I know, Philip said, which is why they're hoping the judge doesn't know your background in depth. We spent 3 evenings preparing for the main hearing. I had spent most of my career building cases. I understood how evidence worked, how testimony worked, how the space between facts and narrative could be either filled with truth or exploited with confusion. Wakefield was counting on confusion. Our job was to make the truth so clear it left no room for it. On the morning of the hearing, I put on the same charcoal suit I'd worn for important federal depositions since 2003, and I drove myself to the Travis County Courthouse. The courtroom filled steadily. I recognized one of the Fowlers, the retired couple from Bexar County who had lent Donovan $110,000. Sitting in the gallery with a woman who appeared to be their adult daughter. 2 other faces I recognized from Sylvia's report, more of Donovan's private lenders. They'd come to watch. Donovan and Lee arrived with Wakefield. Donovan was still well-dressed, still projecting a version of confidence. But it was performance now rather than genuine ease. I could see the difference in the way he carried his shoulders. Lee sat beside him and spent the first few minutes studying her hands. Judge Adeline Forsyth had been on the bench for 18 years. Her reputation was methodical, thorough, and intolerant of courtroom theater. Wakefield went first. He was skilled. I'll give him that. He presented a narrative of a devoted daughter, an overbearing father, a family in conflict over how to handle a complicated estate. He used photographs, Lee and me at Christmas, at her college graduation, to establish a relationship that looked warm from the outside. He questioned my mental acuity, gently, obliquely, suggesting that a 64-year-old retiree might have signed documents he later didn't remember, might have experienced confusion that he was now projecting as malice onto others. He didn't call it dementia. He didn't have to. The implication floated in the air. Philip let it float. Then he dismantled it. He started with the professional history, the 31 years with the FDIC, the federal court testimonies, the methodology papers, the national commendation for fraud detection work. He established, methodically, that I was among the most credentialed individuals in the state of Texas to evaluate the authenticity of a notarized property document. Then, the evidence, the forensic report from an examiner named Thomas Greer, 26 years of experience, court certified in 4 states, showing the forged signature with 96% statistical certainty. The side-by-side comparisons of pen pressure, stroke formation, letter proportions, Cecile Wainwright's sworn statement, along with her handwritten log, confirming that she notarized a healthcare proxy and nothing else. The outdated seal design, an impression registered prior to my most recent property filing update, which meant whoever lifted it had done so from a document I'd signed more than 18 months ago. Then, the text messages. When Philip read the Donovan Birch exchange aloud, "She knows what to do," I heard the Fowler family in the gallery go very still. Donovan's posture changed in a way that had nothing to do with decision-making and everything to do with the body's involuntary response to understanding that a situation has become irreversible. Lee put her face in her hands. Wakefield objected to the text messages on procedural grounds. Judge Forsyth reviewed the chain of custody documentation, the attorney authorization, the legality of the acquisition. She overruled. Her expression, as she read the exchange herself, was the one I recognized from 3 decades of watching judges encounter evidence that removed all remaining ambiguity. "Mr. Wakefield," she said, Setting the papers down. Do your clients have any response to this correspondence? Wakefield stood. Your Honor, we'd request additional time to review. You've had 3 weeks. Silence. She looked at Donovan and Lee for a long moment. Then at the documents in front of her. The quitclaim deed dated October 14th is declared fraudulent and void, she said. All property rights to 4114 Sycamore Ridge Court remain with the plaintiff, Miles Chadwick, effective immediately. The countersuit is dismissed with prejudice. She set down her pen. Furthermore, the evidence before this court indicates premeditated document fraud, seal forgery, and what appears to be a broader pattern of financial exploitation. I'm referring all materials to the Travis County District Attorney's Office and to the Texas State Securities Board for immediate review. This hearing is adjourned. Her gavel came down. The sound was very clean in that room. I stayed seated while the gallery emptied around me. Philip was speaking to someone near the bench, a clerk, a colleague. I wasn't paying attention. Across the aisle, Wakefield was packing papers with the focused efficiency of a man who wanted to leave quickly. Donovan was bent over the defense table, both hands flat on its surface, staring downward. Lee was standing near the courtroom exit. She was looking at me. I looked back. I didn't know what my face showed in that moment. Probably nothing useful. Probably the same controlled neutrality I'd developed over 30 years of professional life. The same expression that Elena used to tease me about when I came home from difficult cases, and she could see I was processing something I hadn't finished processing yet. Lee opened her mouth. Then she closed it. Then she turned and walked out. 2 plainclothes officers were waiting in the corridor. I heard about it from Philip afterward. Donovan had been detained for questioning related to the financial fraud investigation, which had expanded significantly once the DA's office received Sylvia's full report. The 6 private lenders, the falsified investment documentation, the payments to Clayton Birch, who turned out to have a prior FTC complaint in another state that had somehow never resulted in formal charges. Lee was released without arrest. Her cooperation with the DA's investigation, which had apparently begun through her own attorney the week before the hearing, had been noted. Philip found me in the hallway afterward, looking more composed than I felt. That's about as clean as it gets, he said. It's never clean, I said. It's just resolved. He nodded. He understood the difference. The sentencing came 4 months later. Donovan received 3 years in state prison for document fraud and property theft, with a consecutive 2-year federal sentence for wire fraud related to the private lender scheme, pending restitution of $340,000. Clayton Birch, charged separately, accepted a plea agreement that included a permanent injunction against operating any financial or estate consulting business in the state of Texas. Lee received a suspended sentence, 2 years of probation, and 400 hours of community service. Her cooperation had been substantial. Her testimony about Birch's methodology had been, the DA told Philip afterward, exceptionally detailed and credible. I wasn't in the courtroom for either sentencing. I'd said what I needed to say through the documents and the depositions. I didn't need to watch the gavel come down. What I needed, it turned out, was to be in my garden. I spent the afternoon after Donovan's sentencing pulling weeds from Elena's rose bed along the back fence, which had gotten overgrown during the months of legal proceedings. The roses didn't care about any of it. They came back every summer regardless, because that's what roses do when the rootstock is good. They persist through neglect, through harsh winters, through circumstances that should reasonably have killed them. I thought about Lee, not the version of her I'd seen in the text messages. She knows what to do, but the version from before any of this. The one I'd been trying to protect by not asking hard questions, by signing documents without reading them, by wanting so badly to believe that her return to my life was genuine. Maybe some of it had been. I didn't know anymore. The wanting and the calculation had been so thoroughly intertwined that I could no longer separate them, and I suspected she couldn't either. 6 weeks after the sentencing, a letter arrived, handwritten, 3 pages. Lee's address in the upper left corner. A new address, an apartment across town, not the place she'd shared with Donovan. I put it on the kitchen table and looked at it for 2 days. Then I read it. She didn't make excuses. That was the first thing I noticed. She explained. The debt, Donovan's pressure, the way the plan had been presented to her incrementally until each new step felt almost reasonable given the steps that had already been taken. She explained the moment she understood. There was no longer a version of this that was okay, and the weeks she had spent paralyzed before finally going to a lawyer on her own. She said she understood if I never wanted to see her again. She said she was sorry in a way that was specific enough to be believable. Not I'm sorry for everything, but I'm sorry for January, for sitting at your kitchen table and knowing exactly what I was building toward. The particular sorrows, the ones that required acknowledging specific choices rather than hiding behind generality. I folded the letter carefully and put it in the fireproof file cabinet, in the same drawer as the original deed. I didn't write back. Not that day. But I didn't throw it away either. Deputy Pierce came by a few weeks later on the Saturday morning. He was off duty, in civilian clothes, and he brought coffee from the place on the corner that I had been going to since it opened. We sat on the porch. He asked how things were going. I told him the case had resolved. He already knew most of it. It had been covered locally, and the way fraud cases involving elder exploitation tend to be covered, with a mixture of legal detail and human interest, that I found both useful and exhausting. I should have looked more carefully at those documents before I served them, he said. You served papers that appeared legitimate, I said. When you saw something was wrong, you stayed. That's the job. He nodded, but I could see he was still curing it, the professional discomfort of having been, even briefly, an instrument of something fraudulent. That's the weight that comes with doing work that matters. Every mistake, even the ones made in good faith, stays with you. You'll make a good detective, I said. He looked at me. How do you know I'm testing for detective? You came here on a Saturday morning in civilian clothes to follow up on a resolved case. That's not patrol officer behavior. That's investigative instinct. He smiled for the first time. Exams in March. Good luck. After he left, I went inside and made fresh coffee and stood at the kitchen window looking out at Elena's roses, which were starting to bud again. The garden needed work. The house needed some attention too. I deferred maintenance during the months when everything had been in legal limbo, not wanting to invest in a property whose future was uncertain. It was certain now. Mine. Paid off. My name on the deed. My signature properly formed. My seal properly placed. I spent 31 years watching what happens when people believe that age or trust or loneliness makes someone a safe target. The calculation is always the same. They won't notice, or they won't fight back, or by the time they understand what happened, it'll be too late. What those people consistently fail to account for is that the qualities that make someone appear vulnerable, patience, careful observation, a long career spent understanding exactly how fraud works, are not vulnerabilities at all. I poured the coffee, went to the back porch, and sat in Elena's chair. The roses were coming back. Some things always do. People ask me sometimes whether I regret how it ended, not the legal outcome. Nobody asks about that. They mean the other thing. Lee. Whether I regret pursuing it all the way to the end, knowing what it would cost her. I don't have a clean answer. I've thought about it enough to know that a clean answer would be dishonest. What I do know is this. The moment I stopped reading carefully, the moment I sat across from my daughter at my own kitchen table and signed documents I hadn't fully reviewed because I wanted so badly to believe something, that was the moment I handed the situation to someone else. Not to Lee, not even to Donovan. To my own wanting. And wanting something doesn't make it true, no matter how long you've wanted it, or how reasonable it seems that it should be. I spent 31 years at the FDIC, watching people make exactly that mistake. Not stupid people, not careless people, but people who trusted where trust hadn't been earned, because trust felt better than scrutiny. The fraud always found that gap. It always does. Not because fraudsters are particularly brilliant, but because most of us are reluctant to believe the worst about the people we love. That reluctance is understandable. It's also a vulnerability that certain people will exploit without hesitation. Donovan exploited it, and Lee, whatever her reasons, let him. The part that took me longest to sit with wasn't the forged deed or the scheme or even the text message. She knows what to do. That one landed hardest. The part that took longest was understanding that none of it would have gotten as far as it did if I had paid attention the way I was trained to pay attention. I chose not to. I chose comfort over rigor. And that choice had consequences. That's not self-punishment. It's just the honest accounting of what happened. Actions produce outcomes. Choices produce consequences. Not because the universe is arranged to teach lessons, but because that's simply how cause and effect operates. You stop paying attention, and the thing that requires your attention gets away from you. What I also know is that fighting back required the same qualities that I'd spent a career developing, and then mostly set aside when I walked away from the FDIC. The patience to build a case methodically rather than react emotionally. The discipline to let evidence speak instead of anger. The steadiness to keep going when what you're uncovering is genuinely painful. When the person on the other side of the fraud is someone you raised, those qualities aren't special. They're practiced. They're the result of showing up to difficult work for a long time and deciding over and over again that truth matters more than comfort. Lee's letter is in my file cabinet. I haven't thrown it away. I haven't written back yet either. Maybe that'll change. Maybe it won't. Some things take longer than a court calendar to resolve, and I've learned enough to know that I shouldn't force a timeline on something that isn't finished settling. In the meantime, the roses came back along the back fence. The same way they do every year. The house is mine. The deed has my name on it, my real signature, my properly placed seal. I go to the garden in the evenings, and I think about what it cost, all of it, and I decide each time that it was worth paying.